Good time. Okay, we are at a little past 2:30 now, so I'm gonna call the meeting of the House Study Committee on Annexation and Cityhood to order. Before we get started, I would like to ask Chairwoman Darlene Taylor if she wouldn't mind to lead us in a word of prayer.
Thank you, Mr. Chairman. Please bow your head. Good afternoon, Father. Thank you for the day you've given us and the opportunity to serve the people of Georgia. I ask that you give us discernment and wisdom as we deal with these important issues that affect all of our citizens. We ask these things in Christ's name. Amen.
Amen. Thank you. Okay, today we are having our fifth and final meeting of this committee. Before we get into that, I'd like to thank everyone who has participated, both committee members, people who have participated as far as testimony and presentations to the committee. We couldn't have done this without a few other people who have been in front of you and behind the scenes a little bit. Blake Doss to my left here, our budget and research analyst, has just done tremendous amount of work on this for us and with us. Stuart Morelli from Legislative Council has been a great resource for us and been with us along the way. Delane Roberts, my administrative assistant, has assisted as far as coordinating meetings and getting rooms together. Molly Aziz from the research office also has helped out a lot, as well as Justin Speck with Media Services. These guys will follow us around even when we went to Cherokee County. So thank you, all of you, and thank our committee members for the work that's been put into this. Today's meeting is going to be a review and a discussion amongst the committee of our final report and committee recommendations. Just to kind of give you some brief thoughts as we go through this process. We haven't really put a sign-up sheet. We haven't really posted to have public comment, and we're going to reserve that to the discretion of the committee members. If we have questions that come up during the process that somebody might could be able to assist in answering or understanding, we'll open the mic for that. We will, in just a few moments, be reviewing potential committee or proposed committee recommendations. As we go through these recommendations, I just want you to remember these things, and this is to the committee and to the everybody listening. These are conceptual recommendations to members of the House. This is a study committee. This is not a standing committee. We're not here writing legislation today. We're here reporting observations, reporting our interpretation and results of testimony and presentations that we've heard. Phrases, wording, and terminology are not intended to be final. Any proposed legislation that does come out of this, of course, will have to be drafted by and approved and reviewed by Legislative Council. And then finally, an inclusion in this list of any thought, idea, recommendation does not imply its constitutionality, its practicality, or validity under any state or federal statute. These are purely ideas, thoughts, and recommendations to go forward. The next step is the tough step, because that would be the production of any proposed legislation to be introduced in the next legislative session. With that, I'll turn the microphone over to Blake, who is going to give us just a brief overview of the layout of our proposed final report.
All right, I'll be brief. On page 2 and 3, we have our introduction. Talks about our resolution, the creation of the committee, the days we met, and the folks that were on the agenda that testified to us. Pages 4 to 11, you found your committee findings. Those are broken down by meeting and then subtopic. And then 11 to 14, you have the committee recommendations that Chairman Anderson just went over, and we'll go over those a little bit more in detail in a second. And then 15 to 17 is Appendix A, and that is a record, a thorough but not comprehensive record of the recommendations that were submitted to us over the course of our 4 meetings and through emails and the like. Chairman.
Thank you. And I will say this, Blake and I had a discussion early on in this process, and we had hoped to keep this report a little shorter, but as we got into everything that was discussed and reviewing the film and the documentation of what all was discussed and brought up before us, it became evident that to truly memorialize the findings of this committee and the hearings that we've held was going to take a little bit more than 10 pages. So I apologize for the lengthy nature, but Blake exceeds expectations, and he did on this too. With that, I'd like to move us directly into the committee has had this proposed draft report since yesterday afternoon, and had an opportunity, I hope, to review both the first portion of it, which I would consider the kind of an account and a summation of what we've discussed and heard. And then let's go directly to the proposed recommendations. And these will be proposed recommendations from the committee. The way I'd like to do this and the procedure, yes, let's see, okay. The way I'd like to proceed with this is for us to have go through line item one at a time on these items. And as we do that, open the floor to committee members for discussion, recommendations, and even a recommendation if the committee decides to strike an item off as a committee recommendation. So if that's acceptable to everybody, we'll proceed in that manner. Okay. Yeah, let me recognize Chairwoman Oliver.
Thank you, Mr. Chair. I also want to commend Blake. This is really a good report. It's very detailed and very dense, and I appreciate how much effort it took. You told us how you want to proceed, and I'm happy to try to follow that lead. As I make suggestions or comments, I'm not suggesting them as amendments formally for votes, because I assume that's not how you wanted to proceed. You just wanted us to discuss it, and then you make whatever decision you want to procedurally. I didn't want to get bogged down to a lot of amendments since we are not drafting legislation. And for the committee's information, I've shared almost all of what I'm going to say to y'all with Chair Anderson and with Blake.
Thank you, Chairwoman Oliver. And what you said is absolutely correct. My intent for this is for us to go through and get as close as possible to perfection of the document. And then at the end of that, we'll entertain a recommendation or a motion from the committee to adopt a document as amended in this meeting. So, okay. And Representative Thomas.
Well, my comment is actually a little more anecdotal. I want to thank all of y'all to coming up to Cherokee County. It was a pleasure. It's been a pleasure serving on this committee with all of you. I have to tell you, I've learned more about annexation from Mary Margaret Oliver than I hope to ever know, which actually didn't make any sense now I think about it, but she knows more about it than I'll ever know. Let's put it that way. Blake, thank you. This report is fantastic. I pre-read it last night. I think you really hit all the highlights. And I appreciate all your hard work in this effort. And Mr. Chairman, I also appreciate all your hard work. I know you've put in quite a bit of time behind the scenes to get this done, get us where we need to be, and pulling all the meetings together and working with our special interests and lobbyists here. So thank you very much.
Thank you. And in the words of Walt Disney, sometimes to get things done, you have to stop talking and start doing. So let's start doing. Blake, would you like to begin going down our list, and then we'll kind of tag team this as a group?
Yes, sir. So on page 12, under Department of Community Affairs, a county should be required to notify the Department of Community Affairs of its intention to object to an annexation on the same day the municipality is notified.
Okay. And what I'll do is, as we read one of these, if anybody has a comment or something they want to address regarding that, just, notify me through your microphone. And other than that, we won't hurry through, but we'll go through.
All right. DCA should develop the method by which arbitration panels should operate.
Go ahead and read it as it is.
DCA should develop a list of court reporters that an arbitration panel may choose to employ.
I'm sorry. I was thinking there was some more. Chairwoman Oliver.
This is a mixture of style and substance, and Stuart Morelli can correct me, but sometimes what we're basically asking the department to do instead of develop a method is to issue rules and regulations. And rules and regulations would give the department the opportunity to include a lot of other recommendations in this report. It also, and this is where I'm not clear because I don't think we're consistent, rules and regulations are frequently submitted to chairs of relevant legislative bodies. And in a final analysis, I would want the rules and regulations for the DCA to be submitted to the chair of government affairs. You get those regs now.
And I do get them from others.
That's just a little bit of a technical correction that would create a public process for the way they would issue a method for developing these panels with more precision.
So as I understand it, your recommendation would be to replace the word "the method" with issue rules and regulations, and then also to add verbiage in there to require that that those rules and regulations be provided to the chair of the governmental affairs.
Yes, sir.
Okay, thank you. Stuart.
Just to clarify, I haven't looked at the annexation statute, but for a department to have the power to draft rules and regulations, the General Assembly has to give them that power and outline a broad policy framework for the department to, again, kind of fill in the procedures on. So it's not just, it wouldn't just be, legislation asking DCA to draft rules and regulations. It would need to be granting DCA that power and setting a policy guideline that they stay within when they draft those rules.
Issue rules and regulations now because they've done it in other matters, I think, but you're more, that's a detail.
I just haven't looked at the annexation statute in a few months, and so I don't remember off the top of my head.
Okay, just another comment on that particular subject. Again, these are conceptual ideas. We do want to perfect the language as much as we can, but should a member of the committee or a member of the House choose to include that provision within proposed legislation, and of course, Stuart will further review that and go from there. So,
All right. Bullet number 4, DCA should maintain a record of arbitration panel results. The department should produce, maintain, and annually update a record of arbitration cases. Funding should be appropriated to the Carl Vinson Institute of Government to provide for at least one training per year to increase the number of eligible panelists for the arbitration panelist pool maintained by DCA.
Representative Leverett.
Thank you, Mr. Chairman. That one provision in the court reporter about the wages being divided evenly between city and county, I'm assuming that's to be consistent with the provision down here, which suggests an equal sharing of costs as opposed to the current. I don't know that I would necessarily agree with that, but I'm not sure what my, that I would necessarily not approve the report over that. That's just something I have a little bit of a concern about, is going toward the half and half model. It's changing from what it currently is. So I just had a point of inquiry on that. Is that something I could submit a minority report on if we approve it that way? Or is it something I could just have a little discussion about? Is that what the committee feels it wants to recommend?
Representative, at this point, we would be open to some suggested alternative language if you have some.
Well,
if you'd like to reserve that.
I suppose my suggested alternative language was to leave the cost sharing the way it is currently as to all costs. And I'm assuming court reporters' wages would be included in that, although I wouldn't necessarily be opposed to making just that portion of it shared equally. But I don't feel that changing the cost sharing is particularly appropriate. So
Okay.
I just state that concern.
All right. Chairwoman Taylor.
I disagree. That's just the way it is. It should be equal. It's the two government entities. There's disagreements. I guess that will be in whoever brings whatever legislation from it, because to me, it should be shared equally.
Okay. Chairwoman Oliver.
I want it shared equally too. And one of the things that came to my attention this week, which I did not know about, and I fault myself for this, there's current and I shared this with the chairman, there's current litigation of Brookhaven versus DeKalb County on defining cost. And they're in a dispute based on what is the cost. And that started me asking myself that question. So that's another issue of down the road in some way, but what is the cost? But from my perspective, my vote would be to equalize the cost.
Okay, thank you. And Representative Thomas.
Yes, I'd actually, I also am for sharing the cost equally. And I believe that there was testimony in the Cherokee County Committee when we were in Cherokee County where the mayor, and I don't want to put words in his mouth, but I believe that he was Mayor Steve Miller of Holly Springs, said that he felt like equal cost sharing was probably appropriate. I'm not going to put words in his mouth, but I'm pretty sure that that was stated in that committee meeting. And I believe Mary Margaret Oliver or Representative Oliver followed up with that and just as a clarification. So if my local mayor supports it, I support it. So that's all I have to say on the issue.
Okay, Representative Leverett.
To quote Forrest Gump, yeah, that's all I have to say about that. But, I would just say, I don't believe that mayor spoke for every municipality in the state. So I still have my concern, but I can see that I am truly in the minority on that point. Thank you, Mr. Chairman.
Just a point of clarification, Representative Leverett, is your objection to the statement that's in this particular line item because you feel it's a duplicate of when it comes later, or just the concept of equal distribution itself?
The latter.
Okay.
The latter.
Okay, thank you.
Although I would not necessarily be opposed to carving out court reporters' wages from the general rule, I am opposed to putting everything in an equal 50-50 cost sharing
Gotcha.
basis.
Okay, thank you. All right, at this point, we will continue, and what we will do is any idea like that when we get to the end of the list here and we come to the motion, if you'd like to make a motion to amend at that point, it'll be entertained.
All right, under panel specifics, the term material in code section 3636-113A should be redefined to allow a more broad form of objection to annexations by counties to include the effect on school systems. However, the term should not be removed completely. Panelists should be allowed to serve on no more than 4 panels a year. Arbitration panelists should receive pay equal to the Georgia legislator per diem. The arbitration panel should be authorized to meet virtually. The cost of the arbitration process should be divided evenly between the city and the county. Property owners petitioning for the annexation should pay their own arbitration costs. Yes, sir.
Representative.
I'm going to go back for a second to the first bullet point and tie it into what you just read and a couple other points. The report in several ways refers to people taking certain actions and providing certain information or responding to certain matters in the arbitration panel when they're not a party to the panel. And there are 3 to 5 different instances where you've asked a school system to respond or an impacted local government to, but those people aren't parties. And that brings me back to this primary principle where I may make a motion and may or may not be in the minority, that I want impacted governments to have standing to participate, and that would allow them to be a party. If a school system wants to object to an annexation, it should have a right to make its case in court and not be asked in some way independent of as a third party out there in the wilderness to come and give information. In my county, where new cities are competing for land and where existing cities are competing for land, they're also in the category of impacted government. And so it's both schools and other impacted governments who, I think, in my view, have to be in the courtroom with the right to be in the courtroom, rather than just say, school system, by the way, tell us what's wrong with this proposal.
Okay, thank you.
I won't repeat that comment, but it's 2 or 3 places where you've asked an independent government to do something that's not a party.
Understand, yes. Also, I'll take this moment to repeat a comment you had made to me earlier. Throughout the recommendations, we use the word should, and I'd like for the committee to consider us changing that to shall.
That's always my preference.
Yes. Thank you.
All right. The chairperson of the arbitration panel you want me to go ahead and switch it, shall? Should have the authorization one time to extend a panel's 60-day period for up to 10 additional business days. The affected city and county should be authorized by mutual agreement to postpone or temporarily stay the arbitration process for negotiation and discussion purposes. The arbitration panel should be allowed to attach zoning, land use, or density conditions to the property for at least 3 years. The city and county should be authorized to mutually agree to alternative conditions in a period less than 3 years following the panel's agreement. The panel must provide DCA with a copy of its findings, recommendations, and conclusions. At the same time, they are provided to the municipality and county. If the panel or the local governments affected reach an agreement outside of a panel ruling, the conclusion also must be provided to DCA as well. That's it for that section.
Representative Leverett.
Thank you, Mr. Chairman. Just as to that one section, I have some, I'm not opposed to the initial item about material being redefined, but of course, as they say, the devil's in the details on that. And I've already stated my concern about cost sharing. The provision about property owners petitioning for annexation should pay their own arbitration costs. Is that the cost they pay if they are a party to the annexation? I'm trying to remember, are they generally allowed to participate in the arbitration?
My recollection is that is in case the property owners had either legal expenses or expert testimony expenses,
Okay.
that they would be responsible for that.
Okay, okay, I see. And then,
And I see, let me, not to interrupt, but I see
No.
Chairwoman Oliver has a comment related to that, if we will. Hold on one second.
Confused me about that provision is I was trying to figure out if only a property owner is petitioning to be added to that. I'm going to use Brookhaven. Property owner petitions to be added to Brookhaven, and Brookhaven said no. That's the only reason you would be in an arbitration dispute. So I'm trying to figure out how that comes to bear.
my understanding is you would only be in an arbitration dispute if the county said no.
So-
And so the property owner would be the one desiring the annexation and would have petitioned for it. And I think they do have some right to participate in the arbitration. I think that's what Mr. Chairman just said.
Not just cities and counties, but also a third party, private
Yes.
can participate in annexation.
Yes, yeah.
Well, that explains.
And
On
I
behalf
think
of the
this is
property
just
owner, yeah.
clarifying to the extent they incur costs of that annexation, they can't throw that on the county. That's to be their cost.
Correct.
And I would not have an objection to that, I don't believe. The 3 years, though, I did have an objection to, so I'm just adding them up as we go.
Okay. All right. Chairwoman Taylor.
Thank you. I had number 8, just if you read these things too many times, but it had to, the affected city and county should be authorized by mutual agreement to postpone or temporary stay. What if they don't mutually agree? Then and what if one wants it and one does not want to? Doesn't happen. All right.
Representative Thomas.
I'd actually like to object to the 3 years as well. So I'd like to discuss that a little bit further when the time comes.
Okay. When we get to the end, hold that for a
I
proposed
will. I
amendment. How
wrote it
about that?
right here.
Okay,
Object,
good.
3 years.
Okay, Blake.
All right, under time frame, the county's 30-day shot clock should be extended to 45 days following a city's notification of an annexation petition. A city's notification of an annexation petition should also be forwarded to any affected school system, development authority, community improvement district, or quasi-government entity. Additional means of notification should be allowed throughout the dispute process, including email and hand delivery. Verification of delivery must be required.
Okay, Representative Leverett.
Mr. Chairman, the one thing I would like to just put on the table is there's also a deadline in the statute, an annexation statute that requires a city forward the petition to the county within 5 days of accepting the petition. I would like, since I think we're trying to allow a little more time, in my experience, sometimes the petitions aren't really complete. They're incomplete or they don't have all the materials they need. And so I know some may interpret that 5 days as running from just receipt rather than us deeming it to be complete and accepting it. And it may not be appropriate in this forum, but I was thinking we might try to also extend that deadline a little bit and make it clear that it's the time at which we deem it to be complete and in complete and proper form, so that we aren't rushed into sending the county something that doesn't have all the information they would need.
Okay, good suggestion. Thank you.
And also the quasi-government, and I don't know what extent we're getting into I may be getting in the weeds. That's one of my favorite things to do, which is very frustrating, I know, but quasi-government entity, I don't really have an objection to that conceptually, but I think we ought to, if we have legislation, we ought to specify, because otherwise the city's kind of placed in a tough spot of trying to figure out what that is.
Exactly. Very good point. Chairwoman Oliver.
And in relation to that sentence, the notification of the annexation petition should also be forwarded to effective governments, quasi-governments development authority. That's the best example in this report of you're giving them a copy. You're ordering the petitioner to give a copy to the school system and the development authority, but they're not allowed to come in and talk about it. So that's the best example there of why standing is important for impacted parties. I'm trying to figure out procedurally what would happen if I were on an annexation panel and the school system showed up, knocked on the door. What would I do?
Understand. All right. Thank you. Like,
All right, under bonds, annexation petition should provide an analysis of any public debt and include which entity is responsible for the debt and how it should be provided for following the annexation. A special tax district should be created following an annexation or de-annexation to allow for the collection of bond repayment. Parties represented by an arbitration panel should disclose any tax abatements or tax incentives previously disclosed in the petition process, as well as any abatements or incentives offered, proposed, or negotiated by a government entity.
Chairwoman Oliver.
I really like that provision. Thank you for including it. The one about you got to disclose tax abatements. In the zoning instance, whether it's 1 year you're prevented with zoning or 3 years, there's a sanction for there's a prohibition against doing something that the annexation panel doesn't want you to do. I think there's similarly, whether it's 1 year or 3 years, it should say that if the annexed property, if there's a failure to disclose tax abatements will not be allowed for 1 year or 3 years or whatever we decide as a committee. I like the 3 years myself.
Okay. Thank you. Representative Leverett.
Thank you, Mr. Chairman. I'm sensitive to that issue about bonded indebtedness and the effect the annexations would have on that. So I don't necessarily disagree that that's something that might statutorily need to be included in criteria or analyses. I'm just concerned that the guy who wants to annex his lot to develop it doesn't know what public debt there is out there. And so he can't really analyze what effect it would have. But I think that's something that once you notify affected parties, as Chairman Oliver is suggesting, they would be able to raise that as an issue and it could be considered in the discussion. But I believe that asking the petitioner to analyze that is asking them to do something they simply don't have the knowledge or expertise to do. And as far as the special tax district, I think that's a potential toolbox or remedy that could be done. I'm reluctant to statutorily mandate that it happen in every condition. So thank you, sir.
Okay. Chairwoman Oliver.
And I agree with Mr. Leverett that the party of the annexation can't analyze somebody else's debt. And I suggested to Chairman Anderson earlier, they might just be required to list it. I think there's some visibility of a debt in some public record. Listing it may be a compromise to analyze it. That's just a suggestion to think about.
Yes, Representative Leverett.
Again, I just don't think a developer is going to really know about the debt or have a readily available source of information, provide that information. I think it should be on the public entities that are affected to raise that as a concern. So I do agree that is a valid concern and should be addressed in some fashion. I just don't think the petitioner ought to have to be the one to say what the debt is. I just think that's something that one of the public entities ought to be allowed to raise in the process somehow. Thank you.
And what's important about this discussion, in my view, we're not going to talk a lot about development authorities today, but I'm going to want to talk a lot about development authorities later. And that's an issue of transparency. Thank you.
Thank you. Chairwoman Taylor.
Thank you. I'm trying to understand why the entity that is going to, shouldn't be responsible to know that information. I don't think they should be cut loose from it. They should be at the table. They should know it. They may not be responsible, but it needs to be brought to their attention. And I think everybody should be part of that. So I don't see a problem with them being here.
Representative Leverett.
If I might respond, Madam Chairman, the petitioner is not the city. The petitioner is the property owner, and the guy who's developing his property isn't going to know all the public debt or bonds that have been issued by the different governmental entities in that jurisdiction. So that's why I don't think it's fair to require the petitioner in his petition to either analyze the effect of his annexation on the public debt, because that's kind of an issue, I think, for discussion and resolution. But additionally, I don't think it's fair to require that petitioner to disclose public debt that he didn't really have anything to do with and may not have a ready source of information to state in his petition. I just don't know that it's really reasonable to request that he do it. That's my point.
Okay.
And again,
Thank you. And I will make a recommendation. We'll kind of, as we get through this list, we will probably look at the possibility of taking some of these line items that have particular questions such as this and moving them to an other recommendations list rather than a general committee recommendations list, because there's a lot of questions that are being raised that may not be able to answer at this point.
Is to understand where the issues need to be. You can't be, my goal is to have some consistency about transparency and who's at the table.
Understand. Okay. Point taken. Thank you. All right, Blake.
All right, I apologize for the length of this one. The government entity involved, this is under mapping, involved with annexations or de-annexation should be required to report the corporate boundary change to both DCA and the Legislative and Congressional Reapportionment Office. In addition to current reporting requirements, the government should send boundary changes in a digital shapefile to ensure more efficient mapping processes. For municipalities unable to meet this requirement through their own geographic information system department, regional commissions can be required to provide a digital shapefile in concert with and on behalf of the local government. The regional commission component may be contingent upon an increase in legislative appropriations for DCA's planning contract with regional commissions.
Okay, we'll move along. Representative Leverett.
and again, I know this is just a recommendation, but is the idea that if the regional commission component is not funded, then the city would not be required to produce GIS, system type data or shapefile data. The reason I ask is I'm pretty sure my city probably does not have that. And while I agree that's a great idea, I want to make sure we don't impose a condition on cities that a lot of the smaller cities are going to be not going to be capable of complying with in its technical format. So I think in the recommendation is the regional commission component may be contingent upon an increase in legislative appropriations for DCA's planning contract with regional commissions. That suggested to me that there may not be regional commission capability in all cases. And if there is, and the city can rely on that, then I don't have an objection to that at all. I just want to make sure we're not requiring cities to do something and providing they have an alternative that may not actually exist.
I think they have it, but that's something to verify.
Well, and one thing we may want to consider is, again, in a motion, and I may reserve this one, to remove that last sentence that basically came from a recommendation in the discussion and testimony we had as a mechanism to ensure that that expense was covered. So
I appreciate that sentence. I didn't mean to necessitate that, but thank you, Mr. Chairman.
okay, thank you. We'll continue.
Under school systems, annexation petition should provide an analysis analysis of any potential impact on school taxes and school attendance. Annexations affecting a student school district should not go into effect until the current school year ends. The General Assembly should develop a framework for which local school systems can share revenue following an annexation.
All right, Representative Leverett.
So, Mr. Chairman, same concern about that first one that I had above about making the petitioner analyze potential impact on school taxes and school attendance. I don't think they're going to generally know, but I do think that it's very legitimate and valid. And that's sort of a concept that, Mr. Chairman, thanks to some of the testimony we heard due to your leadership, that we realize is a concern for a lot of local systems, independent school systems and county systems. So I do think that's a valid concern and an issue that should be raised. Again, I'm not sure the petitioner needs to be the one addressing that in the first instance.
Good point. Thank you.
All right, last two. The General Assembly should codify the city creation process. And secondly, in order to create a fair process regarding obsolete county infrastructure within a newly created city, the General Assembly should codify similar language found in the Annexation Code section in the Cityhood law.
Okay, that's a brief review of those, and I'll recognize Representative Leverett.
Just had one question about the last item, Mr. Chairman. I could not remember what the similar language is that we're talking about. Is that the one where the county would have the right to sort of do a put to the city to pay the fair market value for any infrastructure they annex?
Okay, to answer that, Clint, would you be able to come to the microphone and answer that question for us?
Sure. Thank you, Chairman, members of the committee. I think what's being discussed here is in the annexation. Let's see. So when we're creating new cities, there's specific language in the law about how those county assets get transferred over to the new city. And we don't have that in annexation. And then also for compensation for those assets. And then I think for the annexation, the other issue is if an area becomes sort of obsolete, if you will. So if you had, say, a fire station that served a particular area, and there was a large annexation where the annexation, say, took out half the area of the fire station that they served, then you've really made it functionally obsolete at that point in time, right? Because that fire station lost half their service territory, and it really doesn't make sense for it to be located there. So I think that's part of the consideration is if you have something like that changes the service delivery area of an asset like that, then how do you compensate for that?
Okay, thank you. And I'll recognize Chairwoman Oliver.
Witness a question.
Yes, ma'am.
I was totally confused by this throughout all of our new cities and annexations. And so I think something needs to be done. But here's my specific question. Does it say somewhere in something we passed that you only have to pay $5,000 for a park or $5,000 for a library or $5,000?
Yes.
See, that's bad.
So when we were dealing with the incorporation of the new cities, and obviously it started, I think, with Sandy Springs, and then obviously in DeKalb County, you had Dunwoody and Brookhaven. There's language that was put into the law about what that compensation would be depending on the type of asset. And I don't know off the top of my head, I can't tell you what that is, but that was determined, so what was sort of given at a nominal value, then and what types of things would they have to pay fair market value for.
And that all was played out. And again, in my district, in my neighborhood, or county, $10 million was exchanged for the fire station next to the CDC. So, I mean, this is just a mess in the law. Just sum it up as a legal term, a mess.
I guess I think the point here, without getting into the weeds, is the same issues that exist for the incorporation of a new city could exist with an annexation, and having parity. Whatever you put in the law for incorporation of a new city should probably be the same type of language used for annexation when an asset is being transferred from one governmental entity to another.
And my memory is that we did that badly the first time, so we shouldn't do the same thing.
Maybe we need to look at the whole thing.
Okay, thank you. If I may, I'd like to ask Stuart to give us a little bit of there we go, a little clarification here.
Unfortunately, I don't know how much more clarification I can give. I haven't looked at the statute in a while. I think there's definitely procedures in the cityhood statute for transferring certain facilities in the event a new city is created. I think there might be some lesser provisions that deal with annexations. Frankly, right now, my mind is so clouded with redistricting law that remembering what's in annexation is, I'd have to go back and look at the statute to be of any real input, probably.
Okay, thank you. Thank you. Chairwoman Taylor.
I'm going back on something on the previous page, and that has to do with the petitions. I know when you're using the example of a single person moving a parcel into being annexed into a city. I'm thinking bigger, like you've got somebody getting, 500 acres and they're going to build 600 homes. Do we, or can the county require the builder, the developer to build a school? That I've seen that happen, but is it something, that's why I think the school systems need to be at the table. And I do think they should be responsible to know if you're going to build 500 homes, that's going to be X number of children, and that's affecting it. Actually, I'm just as bad on what their need is to know the roads that are going to support a system like that. I'm not as worried about the one single landowner that's accessing city, but I think that's a bigger picture. So we've got two different things trying to balance, small and large. Thank you.
Representative Leverett.
Thank you, Mr. Chairman. Trying to remember, Clint, to your statement, my recollection is there's an existing provision in the annexation law that allows counties to require cities to compensate them for fire stations and infrastructure that they end up taking into their limits. And I didn't think it said 5,000, maybe that's a different statute, but I thought it did provide, I thought, for some kind of fair value. I was thinking this was in the incorporated islands. Let's see. I can find that. I'm sorry.
Representative Leverett, while you're looking at that, if I will, I'll grant the microphone to Stuart.
Yes, please do.
I'm fairly certain that the set dollar value for the transfer of assets is in the cityhood, the incorporation of the new city procedure. There might not be a comparable provision in the be related, but not in any way lining up provisions for annexations. From doing this from memory, there are provisions in both and they don't line up, and lining them up might probably be a good idea.
Whichever way it flows, they're not consistent, and you would want them to be consistent either in both statutes.
Annexation ordinance that does allow counties to be compensated, and it's not a set dollar amount. I think it leaves it more broadly to value, but I was not aware of the provision in the cityhood statute. I agree. I think it ought to be consistent.
Okay, we're actually at the point where I would entertain proposed amendments to our list. So I would suggest possibly considering, and we would consider an amendment to adjust the wording of that to basically to suggest cleaning up the and aligning the process between cityhood and annexation. If someone would like to make that motion. And Chairwoman Oliver, you're blinking over here, your microphone.
My comment was not, was simply to say that the two provisions on page 14 cover an enormous amount of ground. And as our discussion has come for the last few minutes, we're really not sure exactly what the law is right now. But these two recommendations are important and true, whether even if we don't know exactly what the law is today, these are two huge lifts that the General Assembly should consider to straighten out all of the, to use the legal term again, mess that exists out there. The litigation that's coming out and would come out for further cities that we know about very close to us physically right now. As a result of that, there's no real path for this about how you compensate entities is huge. So I like the recommendations. I just don't think we can be much more precise about them. So I'm not going to offer an amendment on that. I'll offer amendments on others if you'd like me to.
Okay, well, what I'd like to do is let's just go back and in retrospect, Blake, we probably should have numbered these items just to kind of help. So we'll go back to under the Department of Community Affairs recommendations. Let me make sure I'm on the first page here. Yeah. Department of Community Affairs. I would like to propose an amendment to this on the second line item to remove the words "the method" and instead to develop the method and instead to insert issue rules and regulations, and then at the end of that sentence add to and submit to the chairperson of the Governmental Affairs Committee. Okay, we have a second, and we'll what we'll do is if we get motions and seconds, if there's any discussion.
I just want to clarify, what would the language be as revised? The Department of Community Affairs should prescribe or issue rules and regulations to prescribe the method, or were we taking the method out?
No, rules and regulations would replace method, basically. Just say the Department of Community Affairs should issue rules and regulations by which arbitration panels should operate and submit those to the chair of the Governmental Affairs Committee.
Okay, thank you, sir.
Okay. We have a motion and a second. All in favor, say aye.
Aye.
Any opposed? Okay, we got that changed. Got that noted. Okay, going down the list. Okay. Representative Oliver.
I want to amend item 4, which begins the Department of Community Affairs should maintain a record of arbitration panel results. At the end of the second sentence, the department should produce, maintain, and annually update a record of arbitration. I want to add this language and publish said report on its website.
Okay, do we have a second? Okay, we have a second. Any discussion? All in favor, say aye.
Aye.
Okay. Any other recommendations on that first section? Yes, Representative Leverett.
Knowing the Pyrrhic battle this will involve, and to avoid doing this every time we hit cost sharing, I was going to make a motion that we remove references to equal cost sharing between city and county, both in this provision and later on in the next section.
Okay. Is that in the form of a motion?
It's in the form of a motion, yes, sir.
Okay. Do we have a second? Seeing no second, the motion fails.
Thank you, Mr. Chairman.
Thank you. Okay, we'll move on to the, well, before we leave this, I'm going to make, and this should have been probably done at the very beginning. I actually had it in my notes, but I had it written at the bottom of the page. I would like to make a motion that throughout this document that where appropriate, with consultation of legislative council, we replace the word should with shall. We have a second. Any discussion? All in favor? Say aye. Aye. Okay, we'll do that. Now, next under panel specifics, just going down the list, we'll entertain beginning with Chairwoman Oliver.
I think that I want to, and I'm happy for Stuart to comment on this. It's either a separate item or it is an amendment to item 1. If I was going to amend item 1, I would say to include the effect on any impacted government, including the school systems, and any impacted government shall have standing to participate in a annexation dispute when they are so notified. A better way to say that is to have a separate item that would say any government impacted directly by the annexation in dispute shall have standing to participate as a party in the annexation dispute process. as a separate bullet item.
Okay,
And I make that amendment based on all the comments I've made about you can't tell people what to do and tell them that they've got to give information and they give them notice that they're about to lose $10 million of tax money and not allow them to come into court and say, I want to make my case.
okay. And that's in the form of a motion to add an additional line item relating to that?
Yes, sir.
Okay. Do we have a second? Okay. Seeing none, let's see. Well, we did not get a second, but I will allow comment by Representative Thomas.
Get in by the buzzer. Sorry.
Sorry.
I guess I still don't necessarily understand what it is that you're trying to do. I'm not against what you're talking about. You're going to have to put it in layman's terms for me. I'm not a lawyer. So
If the school system is going to be hurt by an annexation, or the next door city who wanted to annex the property too is going to be hurt and already made deals with people, they ought to have a right to come to the court, the dispute process, and make their case.
when you say the court, you mean like the
Dispute annexation.
disputes?
Yeah, and
The arbitration path.
Yeah.
I'll second that.
thank you.
Okay, so we do have a second now. Any further discussion? Yes, Representative Leverett.
I would just add, if we do allow this process to become that much broader, I feel like at some point we ought to also consider making them share the cost of the arbitration. Because otherwise you're making the county and city pay that truck, and they potentially may not have expanded the arbitration as much as the other entities would.
I don't disagree with that, actually. I mean, if you're going to be a party to a lawsuit, and I'm using the term lawsuit, this is an administrative proceeding. If you're going to be a party to this administrative proceeding, then your costs are a part of the whole consideration for somebody to decide.
Chairwoman Taylor.
How far down an entity do you go? That was why is it going to be, it could be 2 cities, it could be 2 counties, it could be the library system, it could be any number, a university.
The library system is not a separate legal entity.
It's a county usually, or a city. It belongs to somebody.
I'm using the examples that I know in my area where Clarkston, Doraville, and Brookhaven all want to annex the same piece of property and are negotiating tax amendments with everybody.
Yeah.
They're definitely impacted by one single owner. In the school system, we all understand how they're impacted. So to me, I'm happy to get into that detail of who is impacted. That would be a fairly technical definition.
Is it only, what if it's a private property owner that's next door that doesn't want the annex? How broad are we getting?
I don't believe that a private property owner has a ability to issue taxes or fund a budget for public services. So it would be a governmental entity in my mind that's
Okay.
impacted financially in terms of services that have to deliver.
I'm thinking like a large, I don't know, a raceway, anything, a private entity that could be greatly impacted by what we're doing. I get it, but it's affecting the community and the budget and everything else. That's why it gets deeper the more we look at it.
It is. People are impacted as private citizens, as major businesses, but it's the governments that have the authority to tax and the authority to spend for public services.
If I may interject here real quick, and not to cut off the discussion here, I want to make sure that we remember that we're not writing legislation. We are making recommendations, we need to put general knowledge or general recommendations in here. However, the depth and breadth of that proposed legislation, should it come up, would actually be worked out between the author and legislative council. So let's see, I think Representative Leverett.
And Mr. Chairman, as I believe that Chairman Oliver's language was any impacted government shall have standing. And so that would limit it to, Chairman Taylor's question is still well taken. Do you include, like, some library systems do have status as a separate legal entity? But I was going to suggest maybe that's something we could winnow into the weeds on that when we get the actual legislation. Yeah.
Okay, thank you. Representative Thomas has.
Oh, actually, Leverett's always ahead of me. You basically said exactly what I was going to say. So I'm out. Thank you.
Okay, and just one final comment for myself. This part of this actually came from a suggestion that I had made in discussion with Blake, and that is that we want to allow other parties to participate in the process. I don't know if I'm in agreement with giving them full standing equivalent to the city or the county. However, the county being an extension of the state government representing the entirety of the county, including city residents, those objections could possibly be funneled through the county and the county stand in their representation in the process. So, I mean,
That's not good enough for me in terms of being able to make your case based on your individual, which is in opposite to the county's interest. So standing, you can't say to a school system, we want to participate without saying you're a party. And that's where I am.
point taken. Okay, we have Representative Thomas.
Just to elaborate off that point just a little bit, I was witness to an annexation case where the petitioner part of that case came out. Well, and I'll never forget this. The petitioner said, well, the school system's got 4 years to figure this out. I know we're at 105% capacity, but they got 4 years to figure it out. So, and that what I'm hearing Representative Oliver say, kind of that particular statement rings in my head. So, and since this is recommendations, can I put the fourth option? Maybe we put this in other recommendations, since we were talking about an other recommendations document. That's all I gotta say.
Thank you. And at this moment, we have a motion on the floor. We've had a second in discussion, and that motion, I will ask Chairwoman Oliver to restate the motion. Whoop, sorry. All right, hold on one second. Yes.
School systems and impacted government shall have standing to participate in the annexation dispute process.
Okay, that is the motion, and there was a second to that. All in favor, say aye.
Aye.
Any opposed? Representative Leverett. All right. Thank you. Now, we'll just move on down the list. That's a good point. Blake just brought up a point that we've amended to add an additional line item. However, that line item tends to duplicate part of what's in the first line item.
I thought about putting in the first line item, and I'm happy with whatever drafting decision you want to make about that.
Okay, so we'll leave that to the discretion of council and staff to make sure that that concept is included in the unless there's an objection to that. Yes.
Additional part.
Yes, as far as whether it's a separate line item or incorporated in the first item to maintain the intent and content. Okay, going down the list, any other items? I know we have a motion that failed from Representative Leverett regarding the item on the arbitration cost situation.
Make the second motion, Mr. No, I was not going to continue the same motion. Didn't want to waste your time, Mr. Chairman. Say I'll just would appreciate the court granting me a standing objection to that provision.
Granted. Thank you. Okay. Any other items under panel specifics? I do recall some comments about the 3-year time frame. I don't want us to proceed and anybody feel like they were deprived of an opportunity. Representative Leverett.
Mr. Chairman, I just move that we leave that as current law currently exists, which I think is 2 years.
Okay.
It's 1 year. 1 year. I'm sorry,
1 year.
1 year.
Yeah. Okay. We have a motion to strike that from our recommendations. Do we have a second? Okay. Seeing none, motion does not carry.
So far, I'm batting 1,000 if you mention the other one.
Either 1,000 or 0. Representative Thomas.
I actually don't believe that 3 years is long enough. I really would have preferred push it to 5 years. So I'd like to make a motion to change it to 5.
Okay, we have a motion to change 3 years to 5 years. Do we have a second? We have no second, so that motion fails. Any other items on this page? Okay. Okay. All right, the next page, starting under timeframe notifications. I know we had some discussion about this. Representative Leverett?
I think the language I would like to add there, Mr. Chairman, is that the 5-day deadline for the city to submit a petition to the county should be extended to 30 days and should run from the time of actual acceptance by the city rather than receipt, which I believe the law basically does that, but I think there's some confusion and would like that as a recommendation so we can clarify what the term acceptance means.
Okay, and that's in the form of a motion. We have a second and discussion. Representative Thomas?
I was going to second.
Oh, okay. Thank you. Any other discussion? The only thing I will have is just to make sure for Blake and my benefit, make sure we understand completely. You're saying right now, as I understand it, there's 5 days from the time the application is received, whether that's a completed application or just an initial attempt at an application. There's some clarity needed there. But from 5 days of the receipt of a complete and valid application by the city, you're recommending changing that to 30 days. Is that correct?
That's correct. And Mr. Chairman, the language already says, I think accepting, but I just would like for us to specify or clarify that in some fashion in the statute to make it clear that just by taking it in, you don't accept it. But yes, your statement was correct, Mr. Chairman.
Okay, Blake says he has that. Representative Thomas?
Just one question or more of a clarification. So Representative Leverett, when you say 30 days, we're changing from 5 to 30 days from the acceptance of the application for annexation. Now, will that process be able to continue during that 30 days or, I want to make sure our total clock doesn't get wonky because of it. Just
Agree. I think one of the goals that I would like to see us sort of propose, and I think we are largely proposing it, is allowing more time. So as I understand the existing statute, the county's shot clock, so to speak, doesn't start until we send you that petition. When we get it, sorry, pointing to you, Brad. When we get the petition, you're not required to do anything until we send it to the county. And so this would give us longer to just process the petition, make sure it's complete and thorough. And then the county's 30 or 45-day timeframe doesn't start to run until we deliver it to you. So it wouldn't really affect the county's deadline. It would just give us a little more time to process the petition before we have to forward it on to the county.
And it sounds like the purpose behind that is so that way you can get everything that you need together to provide a full package to the county.
Absolutely.
Yeah.
Absolutely, baby. No, I'm talking about to allow more time for the city to give the county the information it would need to consider whether it wants to make an objection.
And that seems reasonable to me. So yeah, thank you.
Thanks.
Okay, thank you both. We have a motion. Did we have a second on that? Yes, we had a second. That's right. We're in discussion. Any other discussion? Seeing none, all in favor, say aye. Aye. Any opposed? Motion carries. I would like to, the second line item had some discussion around the term quasi-governmental entity. Do we have any recommendations or motions regarding that? Seeing, if there's none, I will make one. I would make a motion that we add the word before quasi-governmental entity of affected quasi-governmental entities to just to clarify that. Okay. Okay. And that is in the form of a motion. There was a second. Any further discussion? Okay. All approved. Aye. Aye. Okay, passes. All right, we'll move on to bonds, debt, and taxes. Chairwoman Oliver.
I'm going to offer as a compromise to item 1 under bonds, debts, and taxes to eliminate the word analysis and insert a list of any public debt obligation. I think that those public debts are in the public record. But the
Okay,
analysis is something I don't think they should have to do on behalf of another government. So
okay, so we have a motion. Do we have a second? To promote this to discussion, I will second that motion. Chairwoman Taylor. Oop, sorry.
I'm a little concerned if we change it from analysis. Somebody could put a list and what are they basing it on? I want to see the facts that back up what the list is. And that's where I have concerns. I want to make sure that the factual information is being provided. That's,
the purpose of my amendment is so they don't have to try to analyze it factually. They just have to say there's a bond issuance out there for $300 million owed by DeKalb County, and the city of Buckhead needs to pick it up. I mean, that's
but I think they need to see what it is. I don't want to just see a line item. I want to know what it's for.
and
Do
if
they
there's
not
a
need to know?
bond,
They do.
one of those gentlemen might know exactly what in the bond validation hearing is required to be outlined for the court. That's a public record in the court that says what the bonds are for. Am I right or wrong about that? I think I'm right, but I might not be.
Do we have any volunteers in the audience?
You all know me by now, but for those millions of viewers on the streaming online, I'm Tom Gale with the Georgia Municipal Association. And one thing I think you all have to keep in mind is that when an annexation occurs, the land, if it is annexed, doesn't leave the county, doesn't get relieved of any bond or debt obligations. The county and cities too, when they're entering into debt obligation, general obligation debt, they've pledged the full faith and credit of their government. And so an annexation, the people who own that property, they're going to still be in the county, still owe the debt that the county is responsible for paying. They're part of that. So I would suggest that it's not necessarily an issue, but I would also suggest that I agree with you, Chair Lady Oliver, providing an analysis of what type of impacts there will be would be very difficult for, say, a mom and pop petitioner who wants to get water and sewer. That may basically lock them out of getting water and sewer because they'd almost have to hire a consultant to even find a list online or even analysis. So that's my suggestion that this committee consider.
Mr. Chairman, the witness really didn't answer my question. The other witness who stand up, doesn't the bond validation legal notice state what the debt is and who owes it?
I think the issue is going to be timing, but yes. So actually,
It's public record.
all this stuff becomes public record eventually. I don't know if it's going to be, it's not going to, obviously the bonds won't get issued probably till after the annexation happens. So all these things come later in time, but it was the GASB, the Governmental Accounting Standards Board, which is a national entity that required Georgia, I think about 3 or 4 years ago, through our disclosures on our financial statements, we have to report now the impact from abatements. And I use that term abatement loosely because I know they're not technically abatements, right? But anything that if the development authority is holding title to what is going to eventually be owned by the private sector for purposes of negating the property taxes for the county, city, or the school, or all of them, then that has to be disclosed now. That was a GASB requirement that came from the National GASB Board. So yes, to your question, there is public requirements to disclose that now. But that won't get disclosed obviously until after the bonds are validated and it may be in the next financial year. So it could take a while for it to actually show up in a public record.
My amendment to insert the word list instead of analysis, again, was a compromise to alert the parties in the room that there is an issue of public debt that requires further discussion and analysis by somebody. And that's my purpose. I want people to know what the debt is and know what the arguments are at a minimum about who's going to pay this.
You may want to have, so typically there's going to be a development authority involved in this,
Right.
right? So you may want to maybe, again, you were talking about other parties to this, the schools,
Mhm.
other impacted parties. Maybe in the case where there's a development authority deal that's a part of it, then that party sort of has to be brought in. Of course, I don't know how much information they can disclose about what they're looking at, because a lot of times these projects, there's confidentiality agreements in place, right?
Right.
Because they don't want to disclose what the actual project is. They may say they're going to issue bonds, but they don't want to name the company that's going to build on that piece of property that gets annexed in, because the company doesn't want that disclosed at that time until it actually happens. So you get into the confidentiality issues.
And we're getting into the weeds appropriately so on the issue of transparency of public debt. But my position is that there is a public record. The development authorities exist. They have a public obligation. And therefore, I'm not asking the school system to analyze the bonding debt or the annexing. I'm asking just to make a list. That's my motion, which I can't remember whether we have a second or not.
We have a second. That's why we're in discussion. And
Good.
what I'm going to do is I'm going to wade into the weeds here and pull us back out for just a moment. I've got Stuart over here who's got something to input on this.
And I think I just wanted to clarify that this is, from what I'm hearing, the discussion is actually talking about two different types of bonded indebtedness. Cities and counties and school boards, which have taxing powers, can issue general obligation debt, which is backed up by the taxing power of the jurisdiction. Development authorities development authorities, cities and counties also have this power. Development authorities, it's the main type of debt they're issuing is revenue bond debts, and revenue bonds tend to be backed up by the income generated from a particular facility. And so I just kind of wanted to clarify where it looks like the discussion's merging discussions about two different types of debts, and addressing them might not necessarily make sense to address it as bonded debt, but to identify, revenue bond debts versus general obligation debts, which might be easier for a party to identify.
I'm not concerned about revenue bonds because, the dorm person paying for the dorm room is going to pay that bond. I'm concerned about general bonds and something other that's going to be totally confusing to everybody. To me, it's phantom bonds, the term phantom bonds. I don't want to try to find phantom bonds. I don't know what they are. So, Mr. Chairman, to be helpful, maybe, I think listing public debt is a knowable entity by the parties in the room.
Thank you, Chairwoman. I do have a couple of other microphones blinking, but if I may, again, to try to keep us on track with the purpose and intent of what we're doing here, I would like to, if Chairwoman Oliver would entertain a proposed amendment to her motion for amendment, I would like to make that at this time.
I would like to hear the amendment before I agree to
Okay,
it.
yes, ma'am. I would propose to amend the sentence, the opening sentence of this to say the annexation petition analysis shall include a list of any public debt, and then continue the sentence as it is there. What that does is that relieves the petitioner from having to produce that list, but makes it a part of the analysis process by either the municipality or the county or both.
I accept that amendment. It's a good improvement on what I was trying to do. Thank you.
Okay, so is that a second of my amendment of your?
Yes, sir.
Okay, and we have discussion on that. I'll recognize Chairwoman Taylor.
As we're sitting here discussing this, Stuart, would this apply to a de-annexation? We're talking annexation. What if somebody de-annexes? Do they have to do it too? I mean, it's not stated. Okay. Is it assumed to be applicable? It needs to be added? Okay.
For
Stuart,
the, for
I'd like
the,
to amend your amendment and add de-annex. Yes, it is.
I would say for the sake of clarity, I would not necessarily presume that any requirement that deals with an annexation automatically would deal with a de-annexation unless the statute specifically says it does.
I amended his amendment.
Okay, so we have a motion to amend, and how would that read, Madam Chair?
That's perfect. Thank you.
What's? Okay, so to paraphrase what the chairwoman would say, that I would say annexation or de-annexation petition analysis. Is that fair? Okay, so we're going to back out of this now. We have that motion to add the word de-annexation to this. Is there, we have a second. Any further discussion? Rob, would you like to weigh in on this subject?
Which one, Mr. Chairman?
Well, at present, we are discussing the inclusion of de-annexation.
That I would object to because there is currently no, I just think you're radically changing the de-annexation process if you do that kind of change. What we've been, I think, focusing on, and admittedly, de-annexation was a topic that we did talk about. I just feel like that de-annexation generally has traditionally not had these sorts of restrictions. These restrictions that we're tinkering with and amending apply only to an annexation petition, giving a county a right to object, which they traditionally didn't have until the existing statute was adopted 15, 16 years ago. So I don't believe we should add de-annexation as to that motion. Secondly, as to public debt, I'm getting a little confused myself. I agree with Stuart's delineation of the two kinds of, you basically have geo bonds and revenue bonds. And Madam Chairman, I thought your big concern was revenue bonds because those usually result in tax abatement, whereas the geo bonds don't always result in tax abatement. Because the phantom bonds to me are revenue bonds, but I'm not a bond specialist, so I shouldn't probably say. But I still believe if you're requesting that they disclose the existence of any anticipated public debt that is to be incurred in connection with the annexation, I think you do have some confidentiality and issues with that. To the extent you're asking them to disclose or even make a list of all existing public debt, that's just a very difficult task to undertake because, you know, bonds are sometimes issued 18 years ago and you'd have to call the development authority, you'd have to call the school board, you'd have to call the county, you'd have to call cities. And I just think that may not be intended to have the effect of discouraging annexations, but it would have that effect. And I think property owners ought to have a little more, ought not to have such a high burden to make a petition to annex into a city.
Chairwoman Oliver.
This will be the last thing I'll say because the chair may want to move on this. But this discussion is very helpful because to me, from my perspective, because it highlights the fact that we don't have any law, we don't have any real management of the existence of public debt out there, from my perspective. It's not transparent. We don't know who owes it. We have a huge business interest in development and I think this discussion highlights the fact that we need some additional attention to this. And at a very minimum, if you're going to de-annex or annex $1 billion worth of property, you ought to at least be required to list public debt that we know exists today, not even speculating about future public debt. That's all I have to say.
Okay, thank you. The motion on the table is the last motion that we just have discussed is to add the word de-annexation in addition to annexation when discussing in the line that we're discussing. We have a motion and a second on that. All in favor, say aye. Aye. Any opposed? Representative Leverett. So, okay, that motion carries. So we add the word de-annexation. The next motion, which was my motion, was and it was amended in that motion we just heard. The annexation or de-annexation petition analysis shall include a list of any public debt, and then the rest of that sentence would carry on. We've had discuss any further discussion since we've amended that slightly. Seeing none, all in favor say aye. Aye. Any opposed? Okay, Representative Leverett. And then finally, the amended motion from Chairwoman Oliver originally was to add a list instead of an analysis. And with everything else that we've had in place, you withdraw the amendment.
I
Okay.
think that's what is appropriate.
Okay.
You agree?
That
Okay.
amendment is covered in the motions already made. So that amendment is withdrawn. Okay, we will proceed. Okay, sorry, I'm losing track of where I'm at here. We're gonna try to move this along. Under bonds, debts, and taxes, that was the first item. Any other, let's see, a special tax district, anybody else have any additions, changes? Representative Leverett.
I mean, I don't feel like we need that second one, and would move it be stricken.
Okay, we have a motion to strike the second line item. Do we have a second? I will second that. Okay, Chairwoman Taylor seconds that. Any discussion, comments?
I don't know what it means. So,
I think that is, from my recollection, from our discussion, that was a follow through from the first item that, debts that are identified that are affected. But as Chairman Leverett has alluded to, not every municipality has redevelopment authority, and not every municipality can create special tax districts without that. So there are other complicating factors, and I don't think really that we're getting into further crafting of legislation if we go down that road at this point. So any other comments? All in favor of striking that second line, say aye. Aye. Any opposed? Okay. All right. And the last line in that section. I know there was some discussion, again, not wanting to make sure we don't leave anything out. There was some discussion about.
I'm not going to make the amendment on
Okay.
barring tax abatements for 3 years.
Okay. So you're not.
That amendment.
Okay. Okay, we'll move on to the annexation mapping section. And I think Representative Leverett had a good point when we discussed this earlier regarding the last sentence in that, the possibility of removing that. Would you like to make a motion to that effect, sir?
Yes, sir, Mr. Chairman. I would make said motion.
Okay, we have a motion. Do we have a second? Okay, we have a second. Any discussion? Seeing none, all in favor say aye. Aye. Any opposed? Okay, passes. Now we'll move down to the heading school systems. Yeah, and the first item, well, some of the first item is covered under the items that we discussed under bond, debt, and taxation. Recognize Chairwoman Taylor.
I think this is the one where we wanted to take out petitions. Should it be the local governments that are involved should provide an analysis of any impact if it's not the petitioner? Just change it to local government or the government. Thank you. I move that we remove petitioner and put local government.
Okay, so annexation petition should, may I suggest wording for that motion, Madam Chair?
Please.
I would suggest a review of an annexation petition should include an analysis of any potential impact on school taxes and school attendance.
Perfect. Thank you. Very good. I second that.
Okay, we have a motion and a second. Discussion, Representative Leverett.
And this again may be burrowing down in the weeds, Mr. Chairman, but is the amendment suggesting that that would be provided by one of the participating school districts if it desired so to do?
I'm sorry.
Yes.
I think obviously somebody's going to have to make an analysis, a discussion, or check off an issue on this. The school system may not object. The school system maybe receive this document and not object at all because it doesn't impact that much money or that many children. So I'm not making a clarification of language here. I'm just saying whoever is at the table and wants to object based on school analysis should make that argument. I don't know how to put that in form and that would replace item 2. Excuse me, item 1.
Okay. Representative Thomas?
I support your change to that line item, the change to the change. So, and right now I'm wishing I didn't have that second glass of tea at lunch. So if we can get this vote going, I'm going to step out for a second.
Okay. Chairwoman Oliver, did you have something to add?
I was just going to say perhaps might clarify a little bit is annexation petitions should provide an analysis of any potential impact on school taxes and school attendance by any party who wishes to raise the issue. Alternatively, there's a better way to say that. Were you about to say that?
Well, I don't know if I was going to provide a better way to say it, Madam Chairman, but I just thought if you say the annexation petition should provide, that implies the party desiring the annexation, the property owner who's requesting the annexation.
Okay, let's go back to the motion as it stands at the table was that the wording be changed to the review of an annexation petition should include an analysis. So that does not place the burden upon the petitioner, but somewhere in the process. And again, that where that occurs in the process can be worked out in whatever proposed legislation may follow for that. It doesn't, we are recommending that is included in the process.
I would second that motion. If that's the language that you're offering.
Okay, that's the language. We do have a second.
The only thing I would add, Mr. Chairman, is just to make it clear that the city does not have to do that because the city may not know what the school tax situation is and not be able to do that. But subject to that caveat, I don't have an objection to your line.
Okay, and there again, that's something that could be, if that needed clarification, could be worked out in proposed legislation. We're
Yes.
just saying through this that it needs to be considered.
Right, needs to be there.
Okay, any other comments? Seeing none, all in favor say aye. Aye. Any opposed? Okay. Sir?
I was late raising my hand for an affirmative.
Yes, sir. Gotcha. No problem. Okay, any other items on the recommendations? And again, we are not crafting legislation, we are making recommendations. Yes, Chairwoman Taylor.
The last one under school system, the General Assembly should develop a framework from which local school systems can share revenue following the annexation. I'm not sure what your intent there is there. Do we have to have a new program developed? Is that what we're saying? What are they doing right now?
That recommendation may have come out from the local legislation that came out between DeKalb and City of Atlanta. They'd had a negotiation, they exchanged money, they exchanged the fire department, and from that additionally was additional local legislation that created a process for the annexed area and the city and the county to make an agreement, something, they didn't call it a special district services contract, but it was something like that. It was similar.
Intergovernmental agreement?
I don't know what they called it, and the gazillion-dollar mediation they had, but we did have a local legislation that created a process, and that's what I think that
Do we have something already? Or-
for locally. For
Okay,
our,
so do we not need this if we already have it? I don't
We
wanna-
have a comment from Stuart. I
Okay,
didn't mean to
yeah,
interrupt, but
good.
let's let the legislative council.
Yeah, so during last year's regular session, there was some local legislation dealing with the DeKalb County school system and how annexations by both the city of Decatur and the city of Atlanta would affect
Streamline,
various
yes, okay.
issues of the DeKalb County school system. And I think it was the city of Decatur and DeKalb County agreed to a formula for where when Decatur annexed commercial property, parts of the tax revenue would be split between the city, the Decatur city schools and the DeKalb County school system. And it was an agreement, I believe, that the two school systems came together with and was put into the local legislation. So there is an example of it occurring on a local level, but that does not, would not apply to another future annexation by another independent school system in another county.
I don't think the recommendation says that the state has to do that format for every dispute across the state, the 180 school districts and the 159 counties and the 500 cities. The question is whether or not we need that, since local entities, do we need it as a general framework, or can we allow local entities to create their own local legislation? That's the question.
Okay, I kind of get the idea. It would be good if you could have a process like we do other parts of local legislation. But I am having concern what worked in your area. Would that work in Thomasville and Thomas County? I have a city school and a county school system, and it may not work the same way.
I would make a recommendation. I would make a motion that we strike that line item from our
I'll second
recommendation.
that.
We have a second. Any further discussion? Seeing none, all in favor, say aye.
Aye.
Aye. Okay, stricken. Now we're down to the last couple of items related to Cityhood law. General Assembly should codify the city creation process. Again, a general recommendation. Anything on either of these two items? Representative Thomas.
If there's nothing on this section, I actually have just a general comment that maybe and Representative Leverett might know. When I was witness to an annexation where certain parts of that annexation of these properties was, and I've had several constituents reach out to me about this as well. They were donated to the city for a public park, but it wasn't really made transparent that's something, is that something that's already in our OCGA, or is, because I'd like to make a recommendation that if there's going to be some donation or benefit to the city, that be made transparent to anybody, just through the process at some point. I don't think that's codified. So again, that was a little bit of a left field comment, but just throwing that out there.
Okay, thank you. And we'll table that for
That's fine.
offline discussion. How about that?
Okay. 10-4, got it.
Okay, I think, do we have a motion regarding these items? Chairwoman Oliver.
My goal in making a motion to amend the second item is to mirror the provisions of annexation and cityhood so that they're similar. That's my goal. And I'm thinking to myself, what's the best way to do that? Other than saying compensation or exchange of properties, valuations or exchange of properties shall be similar with annexations and creations of cities. Creation of new cities and annexation shall have the same provisions relating to compensations, exchange of properties, or distribution of properties. Is that inaccurate? Is that, you like that? You want to improve that? Please improve that.
I'm sorry.
I appreciate your honesty.
Could you repeat that, Representative Leverett? I didn't have your mic on.
I said, I'm sorry, I wasn't paying attention.
Just kidding.
I was looking at the language myself, trying to figure out exactly what it said to see if there was
what we're trying to do is, we have a statute right now that I don't think I particularly like, but we want it to be the same for cities as it is, new cities as it is for annexations. And what really needs to happen is that we need to create a process for evaluating properties that are distributed in annexations or in new cities that is a fair process, fair evaluations. But
Okay, for the purposes of our committee and making a recommendation, we could possibly make a recommendation that those policies and procedures and laws be reviewed for clarity and equity.
and for clarity, equity, and for equalizing the processes.
Uniformity.
Stuart, what does our drafter say?
Uniformity is what it said.
Uniformity, that's the word we're looking for.
Okay.
Okay,
Just, in order to create a fair process, that's in the eye of the beholder. So
An
I'm a
equitable
little,
process has a little bit more definition to me of being more equal.
yeah. I don't mind a review of it. Just, this is very broad.
yeah.
I
Okay.
think a review of processes regarding county or city infrastructure shall be developed to equalize provisions for cities and new cities and annexations. Were you paying attention this time?
I was, but I was also thinking of some other language.
Yeah, the infrastructure, I mean, again, I'm thinking rural, it could be a road. It could be a piece of property. It could be so many different things. It's so broad. That's what's kind of worrying me. Some cases, it's a county hospital for me, and
Or a football
yeah,
stadium. or-
right. That's what I mean. So there's a lot in this. It's a very broad.
Okay,
Obsolete county infrastructure does not fit, though, we know that.
No,
Well, I think it's rendered obsolete by the annexation of the cityhood is the county's point. It's obsolete to them. It's like they can't use it anymore because of the annexation or the creation of a new city. It's still pretty and shiny and maybe usable by somebody, just not by the county anymore.
yeah, and I think that may be the point of this line item is not necessarily the transfer of property. It's what happens to obsolete or abandoned or no longer needed infrastructure or property due to an annexation or creation of a new city.
Correct, but I think the annexation process basically allows the county to be compensated by the city for the cost of that infrastructure. I think that's what the counties would like to have with cityhood as well. Is that fair? I don't know if I agree with that, but I think that's the issue as I understand.
Right, okay.
And I think this was saying the purpose of this bullet point was to that we would amend the existing provisions on obsolete county infrastructure in the case of annexations and creation of cities to render the treatment uniform.
I'm good with the first bullet point. I don't think we need the second one. I
that's-
think we do need to scratch the second one. It needs to be included when they're looking at codifying how cities are created altogether.
Is that in the form of a motion?
It's in the form of a motion.
Do a second. Do a second. Any further discussion? Seeing none, all in favor, say aye. Aye. Any opposed? Motion carries.
It's time. I have a motion.
Yes, ma'am.
All
You are recognized.
right, I move to accept the study committee's final report as amended in this meeting and authorize staff to make appropriate adjustments to include these amendments and other structural and grammatical changes as necessary.
We have a motion and a second. Any discussion? All in favor, say aye. Thank you. Meeting is adjourned.